And good afternoon, everybody. I'm happy to be with you today, talking about a topic that is near and dear to my heart. For those that have heard me speak before or have known me for a while, you know that I am a big fan of trying to resolve disputes. And although I have for a long time, I've done a lot of litigation over the past almost 20 years. I find that for business owners in particular, it can really just wreak havoc on your business. And there are, certain businesses, and at the top of those are highly regulated industries like healthcare, where you're resolving disputes quickly and outside of a courtroom can be exceptionally favorable. And that's what we're going to talk about today. As it happens, I happen to have, I've spent a couple of late nights recently doing exactly this. Last Friday night, I was serving as a mediator in a case with some physician business partners in a breakup. That's a very common scenario. We'll talk about that. And then last night, I was working with several other attorneys and clients and going till about almost 10 o'clock last night in a mediation that started in the morning. So I've had a couple of long ones recently, but I'm excited to talk about this today with you. Our topic agenda here is up on the screen. We're going to talk about a little bit about the mediation process. This won't be anything new for any of our attorneys who are watching today. If you participated in a few mediations, you're going to see a lot of stuff that is familiar to you. But then we're going to talk about some of the key considerations and issues, things that come up in the healthcare context that make it a little bit unique. A lot of times mediations, any type of settlement, a conference, any type of legal disputes comes down to if it's outside of family and criminal, really comes down, and even sometimes in the family context outside of custody issues, comes down to money. But there are some other issues that you see a lot, in particular in businesses that are highly regulated, businesses that deal with the public. And we're going to talk about some of those issues. We're also going to see how what the future looks like in some areas where we expect to, where it's ripe ground for future disputes, and where some type of mediation or similar process of dispute resolution can potentially be helpful, and some areas where maybe you're not thinking about it right now. So if you are a business owner, if you're in the healthcare space, or if you're an attorney and you're representing these folks, hopefully you'll find some information, a few takeaways today that'll be helpful in your business and in your practice. And I have this introduction here, and essentially, the first point that I want to make is that litigation is unpredictable. Anybody who has been to trial, if you've done it a few times, I had a trial in early January. I've had a couple this year, and I'm really trying to just wrap everything up as much as I can and focus on keeping clients out of trial and out of court, and focus on my mediation practice in particular. But one of the scariest things that you can hear when you're sitting in a courtroom is for a judge to say something like, let's use common sense. Where you might think that that's a good thing. Common sense, one man's common sense is another man's or another person's, what the heck did that mean? Or how did you come to that conclusion? Or who would ever possibly think that that's a reasonable answer? If you spend time dealing with courts and adverse parties and in the litigation process, you find that it is full of surprises. It is oftentimes unpredictable. You can't control the timing of things. You can't control oftentimes the flow of information. You can't control dirty tactics by opposing parties. You have, I shouldn't say you can't control, but you have very limited control. The courts, we have a good court system. And, when you compare it against other systems that, when people try to come up with other ways to deal with a legal system, our court system stands up pretty well against other systems, but it's not perfect. And there's really probably no way to make it perfect. And the advantage of something like the mediation process is it's still a controlled environment. It still gives the parties an opportunity to be heard, air their grievances, but do it in a private way. And really, it gives you control over your own destiny, both for the lawyers and for the clients. Sometimes you may cut a deal that's not, it's not the most favorable deal, but that's negotiation and that's bargaining. But you have control. You have a lot more control in the mediation context than you do in court, because you can fashion a remedy that all the parties will agree to. And whereas settlement agreements generally will be enforceable, provided that they're written and signed by parties subject to the agreement. I just was recently involved in a case where one of the big issues in the case was that parties were challenging a settlement agreement that had been signed based on some technical purported deficiencies to the agreement. Mediated settlement agreements, once they are signed, we've got law in Florida, and I know there's some in other states. A mediated settlement agreement is generally going to be enforced by courts as it's written. The courts don't want to second guess once the parties come up with and cut a deal. So that's some of the advantages of mediation. We'll talk a little bit about the process here. Where does it fit in your dispute resolution processes and ways to resolve legal issues, in particular outside of courts? Obviously, you can file a lawsuit. That's the first thing everybody thinks of. If you watch TV, you see lawsuits. You rarely see a lot of these other processes, but we have administrative hearings. We have arbitration, both binding and non-binding. This chart that I put up here on the screen lists several other types of dispute resolution mechanisms. Mediation falls into this category where it's a little more formal than just negotiation between parties. You have a third party neutral who controls the process or helps facilitate the process for the parties. There are rules. Florida has rules and statutes that apply to mediation conferences. Most particular among those and most notable is the rule of confidentiality. Once the parties go into a mediation, anything that you discuss in the mediation context can't be used outside of that mediation. That is the purpose behind that, and that the thought process is to facilitate the flow of information and allow the parties to speak freely without worrying that something that they say in the mediation is going to be used against them if they end up in court or if they're already in the litigation process. So with very few exceptions, you can speak your mind and say things in a mediation, exchange information in a mediation, and keep it subject to confidentiality rules. A recent example is actually in both cases that I just mentioned that I've been involved in the last week. Business issues were in play, value issues, business valuation issues were in play, and the parties could exchange valuation reports that they might not otherwise want to exchange right away. Maybe they were commissioned by attorneys and they're not subject to discovery, or there's other strategic reasons to keep that information confidential, but they could exchange that information in the mediation context and ensure that it would remain confidential and not be shared with any third parties and not be used in court. As it turns out, both of those cases that I was involved in also settled. Once you reach a settlement, the worry of it being used in court goes away, but you still oftentimes don't want people sharing that information outside of the mediation. Mediation is more formal than negotiation, but it's non-binding unless the parties reach a settlement agreement. You can be ordered to go to mediation by a court, and most courts will order parties to go to mediation before trial. I'm not aware of, I don't know that I've ever been involved in a case that didn't have a mediation requirement before trial, unless the parties had already mediated prior to filing the lawsuit. So you can be ordered to go to mediation, but you can't be ordered to settle. The mediator acts as a third party neutral. Mediator doesn't make legal decisions, can't force the parties to do anything, doesn't represent any of the parties in the mediation. But the mediator can make suggestions and play the role of the devil's advocate, which I like to do when I'm a mediator, and challenge parties' positions to help them recognize where the strengths and weaknesses in their positions lie, and hopefully facilitate a settlement. A lot of the points here just on this slide for your notes, and so you can take this with you. Again, as I mentioned earlier, the parties in mediation control their own destiny. The process is voluntary. mediation is non-binding in a sense that there's no rule that occurs, there's no orders that come out of the mediation that the parties have to follow. But if the parties do reach an agreement, another point to note is a mediated settlement agreement must be signed to be enforceable. There may be some exceptions to that, but I have litigated that issue both in connection with settlement agreements that were not signed, that were not mediated settlement agreements, but done through another process, maybe back and forth email communications. And I have litigated the issue involving mediated settlement agreements. And there is a particular rule in Florida that does require that mediated settlement agreements, in order for them to be enforceable, be signed by the parties. Don't need to be signed by the mediator, don't need to be signed by the attorneys, but sometimes you'll see them signed by the attorneys, but the parties must sign it in order to be bound by the agreement. And as I said, the process of mediation allows parties to not only control their own destiny, but be more creative. You can fashion a remedy that a court may not otherwise fashion. Oftentimes, a court is forced into a situation where the court will have to decide in favor of one party or another party. A court is not going to put into place, for instance, a payment plan. There's a simple example. If you do if you're fighting over interest in a company, if you have a group practice and there's a dispute over the ownership interest among some of the members, the mediator is, a court is not going to order that certain parties make payments to other parties for an interest that's secured by a pledge agreement and has other obligations attached to it over a period of 3 or 5 years. The court's not in the business of setting up long-term agreements and monitoring. The court is going to give you an order and you follow the order. Which leads me to make another point, by the way, that I mentioned mediations can occur before a lawsuit is filed. And that sometimes is the best, and you'll see some contracts that have that requirement. You can also have a mediation that's ordered by the court or not. Parties can voluntarily mediate before they go to trial in a case that's already been filed. But it's not all that uncommon that parties will go to court. The court will make a ruling, or the court will take a matter under advisement, or a jury will come down with a verdict. And then after that occurs, the parties might, one party might file an appeal. Both parties, multiple parties can file appeals and cross appeals on particular issues that happen in court. All that could drag the process out even longer in the litigation process, and the parties can mediate at that time as well. And sometimes here in Florida, if you have if a court makes a ruling and a case goes to up on appeal, sometimes the appellate court will order the parties to mediation. Not all the time, but sometimes, even if there was a mediation prior to the court judgment or order, the appellate court can order the parties to go to mediation and participate in that process again. And even if there is no appeal, let's say, for instance, that's just a simple judgment. One party recovers at court a judgment for $10 million against another party. Good luck trying to collect $10 million. You may be in for a long-term fight. It's not uncommon that courts enter judgments, and we explain that to clients all the time. Another big problem with going to court and getting a judgment is there's no guarantee that you will be able to collect the judgment. And sometimes the parties at that point will agree to engage in a mediation process to resolve the payment of the judgment or come up with some arrangement to satisfy the judgment. And usually involves maybe a structured pay plan or something else. Another nice thing about having an enforceable mediation agreement is generally parties will not agree to something that's not feasible or something that they can't perform. So if you reach a deal in mediation, more often than not, as has been my experience, and probably hundreds that I've been involved with over the last many years, parties normally perform according to whatever they agree to in the process, where the more common result when you get a court order or a final judgment is that there's still more of a battle to be fought. And parties, especially if they disagree with the judgment, you have people all the time who will not follow the requirements of the court in the judgment, and the court does not go out and affirmatively make people comply with the judgment. There are remedies that you can apply for, but another way to have it more likely than not that the deal that you reach is followed by all the parties is to cut a deal that everybody agrees to and they sign it. I've mentioned the statutes and the rules applicable to mediation. I put them here on the slide that's in front of you, Chapter 44, and also Florida rules and the rules of civil procedure. Mediations can go for, I've had sessions that go into multiple days. I've had sessions that where there's a mediation and it goes for a period of time afterwards where the parties continue to negotiate. Sometimes the mediator is involved, sometimes the mediator is not involved. You get close to a deal, you need to wrap up a couple of final pieces. You can also have something where the parties agree to break and then come back because there's some additional information that they want to gather and they agree to meet at a later time. But usually mediations occur in one day, which is another nice thing. It's more like sitcom laws, I like to say. If you watch TV, you see the parties have a dispute, they go to court and everything gets resolved in a half hour or an hour or in the length of a movie. And that doesn't happen in real life. Litigation can go on easily for years. The trial that I was involved in January was a case that we had not filed the case. It was filed by some other attorneys, but the case was going on since 2012. So that's like almost 10 years that case was involved in litigation. I've been involved in other cases that have gone on for almost as long as that, and I'm sure there's cases that have gone on even longer. So mediation, at least you get some finality and you don't have to deal with that process anymore after you cut your deal. Here's another chart. It's for your use. Little reference point of the mediation process. How do you get to mediation? Oftentimes it's an agreement, an informal agreement, but we often see it in healthcare, and we're going to see that managed care contracts, insurance contracts, resolving some disputes for Medicaid payment disputes. There are oftentimes either some contract requirement that will require that the parties engage in some type of alternative dispute resolution process, and usually that's mediation. When I write contracts, I typically write something like that in. I tailor my language to the parties' wishes, but I tend to try to come up with to make it onerous to file a lawsuit. So I might do something like have a contract that has a requirement that the parties give notice and have a meeting to resolve any disputes and meet formally, which involves not just exchanging texts and emails, but at least one face-to-face conversation, or now you'll see it through video, or at least one active live conversation by phone or video communication. And if that doesn't work, then you can have the parties engage in formal mediation. And then if that doesn't work, you can install a cooling off period, so you don't have this situation where people sit down they're in the mediation and then they want to get up and leave and storm off and they're going to file a lawsuit tomorrow. Or situations that I've seen where people show up and they've drafted the complaint and they make the threat that they're going to file the complaint that day unless they get what they want. That's a tactic that folks use, but you can deal with that as well by writing in a formal cooling off period. The parties must mediate their disputes, any disputes that they have, and they cannot file any action in litigation or arbitration, any other formal action, until at least 15 days has passed following the mediation. And that allows people time to sometimes settle down. Oftentimes things can get heated in that process, and let cooler heads potentially prevail. And if not, then you still have your remedies. I like to, especially in healthcare, because of confidentiality reasons, there's benefits to keeping your clients out of the court file in general. I like all types of alternative dispute resolution, including mediation and arbitration, which can all be confidential. And those provisions normally will have to be in a contract in order to be enforceable to keep a matter out of court. But there's other ways that the parties can get there. I've never had an issue when I've represented a party in selecting a mediator. Clients often ask, like, how are we going to agree on somebody? But oftentimes I've just never had an issue selecting someone where it's been a difficult process. If you're open-minded, you try some new people. Some folks will be worried that the mediator has a relationship with the attorneys. The mediation yeah, a lot of times the attorneys and the mediators, if there's somebody that you work with, I just one mediator that I worked with recently that I've probably done maybe 6, 10 mediations with. Some parties that I've had cases with where we've been on opposite sides, same sides that I've mediated their cases. And there's no, as long as that's disclosed, there's no rule that prohibits somebody from mediating a case. The mediator is required by the mediation rules to be neutral and not advocate for one side or the other. But provided that you disclose that, in my view, it can sometimes be strategically to your advantage. I want to throw this idea out there for the attorneys. If you are in a particularly contentious situation, and you're dealing with a party on the other side or an attorney on the other side who is difficult, if you work with a mediator who has a relationship with that other party and has that person's ear, the mediator wants the case to settle. That's how the mediator makes the bread and butter. If I am the mediator in a case, I want to do everything I can. And part of that is a pride issue. You want to succeed and bring the case to a resolution. Part of it is also just knowing what the parties are in for if they don't settle, and how difficult and draining and ruthless the litigation process can be. So if I know that a mediator has the other attorney's ear or has a relationship with them and has that person's respect, I can sometimes use that to my advantage. Even if I have never dealt with that mediator before, I can express points to the mediator that I might not be able to communicate to the other side and have them sink in and get through, but I can give them to the mediator and let the mediator do that work for me. So I want you to consider that. It's not going to be for every situation, but it is a consideration. And I've had good success in the few times that I've done that, where I know that the mediator has worked with the other side before and I don't have a relationship. Sometimes all the parties know each other, know the mediator. That's fine too. And sometimes it's somebody brand new, and I've seen all of those succeed. I won't go in really to the mediation process itself. That's sort of something that's in flux. Whether you'd have opening statements, just understand that that's confidential. And if you're in that situation, for the attorneys, they know they've been there. Other states, by the way, have different rules. California never has opening sessions. Florida, we typically have an opening session, but I'm seeing folks move away from that. Sometimes it gets a little bit contentious. For myself, if I'm representing a party, I like to keep the opening session usually pretty, I don't want to be too combative. I feel like a lot of times that can start the case off on the wrong foot. If I have some particularly tough information that I want communicated, mediation, by the way, is a great opportunity to communicate with the client on the other side. If you think that the attorney is not giving them a fair picture of what's going on, you can use the mediator for that and make sure that the mediator conveys the information to the other side, the counsel, and the party. And I feel like that's a better way to communicate that information and make the mediator convey that information, so that I can try to put myself in a position of being someone trying to help facilitate a resolution. I want to move on and touch on our, there's another slide. This is just in here for your uses here, some examples of cases that are particularly suitable for mediation. But today, again, we're talking about cases in the healthcare context. And I believe that in medical practices and other healthcare businesses in particular, that this is a particularly good way to resolve disputes. Any business owner doesn't want to be in court, but you especially don't want to be dealing with courts when you have things like patient data and you're subject to HIPAA requirements, and there's all of these regulatory issues that you may have to deal with when people are making claims in a lawsuit. But there are, some cases that, maybe the mediation isn't appropriate, maybe it's not ripe, but you can use this chart as a reference point here. Now, I want to talk about some key considerations in healthcare and why, in particular, some of these healthcare issues are a little bit unique. Some of them overlap with other businesses, but it's a unique perspective on a few of these. First, of course, is patient care. If you have a group practice breakup, You don't want to, business partners can get into disputes and do mean and nasty things and also look like buffoons. I've seen very smart, well-educated people do things that just look silly. Uh, and and when you have a relationship with patients and you have some degree of a relationship with the public and the public perception of your practice and your ability to provide professional services, uh, you do not want to be airing your problems in public, and you don't want the disputes that you have in your business to carry over and affect the operation of your business when it comes to patient care. In particular, again, for healthcare, you are, any healthcare provider or practitioner is a target. And I say this many times, if you're a professional service provider, it's not just in healthcare, it goes for accounting and financial advisors and lawyers, anybody who's in a position to provide professional advice. But in particularly in healthcare, you're a target and you don't want to do anything that is going to create additional exposure. And that is one of the issues that makes healthcare a little unique from, say, maybe an e-commerce business or manufacturing or something else, where you don't have that great concern, where people don't see what's going on with the players on a day-to-day basis. Confidentiality is a huge benefit to mediation. As I said, everything in the mediation process is confidential, and it's a big part of the reason why I like mediation and arbitration for resolving healthcare disputes is you don't have to worry about things like patient records and other issues such as billing concerns, contracts that you may not want to be made public. Maybe you don't want your compensation structure with physicians or other providers to be made public. You have an opportunity to keep all that confidential in a mediation where it's only exchanged between the parties. If you want to do that in court, you have to get a court order. There's always a risk that somebody will oppose the court order or that somebody will try to lift it. You're filing documents under seal. It's just not a great environment. If you're resolving, if you're in mediation or if you're in an arbitration, the parties can just agree from the beginning. Everything that we do is going to be private and confidential, and there's no public record. And this leads into this fourth bullet under confidentiality here, keeping your name out of the court file and not airing your dirty laundry. This goes to your marketing and PR. And PR in this case is your public relations and your patient relations. As I mentioned earlier, you don't want to look the fool in front of the public that you are serving. But also consider that some folks want to, depending on the type of business that you have, if you're a home healthcare business or you have another type of practice that is subject to potentially being acquired by a larger company. There's a lot of movement with public private equity groups purchasing in the medical and healthcare space, different types of businesses and growing those and forming larger conglomerates. One of the things that almost any potential acquirer or business partner or joint venture partner, or even for me, if I have a client who asks and they're thinking about teaming up with somebody and working with somebody or going to work with them, one of the first things people are likely to do is run a public record search and run a court search to see what type of issues are out there. And I know for me that if I see depending on the timing and the age and the size of a group or company or an individual, depending on what their position is. But if I see a few lawsuits, whether the party is a plaintiff or a defendant, if I see a few lawsuits, it just makes me wonder, what is this business or this person doing that they are involved in a half a dozen lawsuits over the past 5 years? I'm a lawyer. It's pretty easy for me to file lawsuits, and I try to stay out of lawsuits as much as possible, either as a plaintiff or a defendant. So keep in mind that just having somebody go and look at a company, I have had situations where clients have asked, and we've reviewed some background information that we found in court records, and just based on the number of times a business appeared in the court record, I have had clients walk away from potential deals. and they just didn't have the gut feeling. They don't want to be involved with somebody who is litigious. And the United States, of course, has a reputation for being exceptionally litigious. And somebody who's in the court file a lot could potentially scare off potential suitors, business partners, et cetera. Another area that makes healthcare very unique, and the reason why mediations can be so favorable to resolving concerns, is just with all of the compliance issues that you have. There is not only are there multiple regulations that cover healthcare, but you have a rapidly evolving regulatory environment. We saw that especially during the early stages of COVID, when the payment requirements and payment allowances were changing at the federal level and then at the state level. Obviously, there was a big push and a move towards doing things by video and allowing people to do stuff remotely. Telehealth in particular changed dramatically during COVID. Prior to COVID, somebody who wanted to, a provider who wanted to provide services via telehealth and collect from a federal payer like Medicare, that process was incredibly onerous. It really only worked if you were dealing with a specialist and you're talking about a rural environment. Now, people routinely see their doctor or other provider specialists without leaving their house. And I think a lot of that, I've done prior discussions on that in these webinars, and I think a lot of that is here to stay, but it also creates issues of a lack of clarity. And I was involved in a situation not too long ago and representing a few physicians where there was in my view, a bona fide dispute over interpretation of the Florida telehealth statute and the interpretation as to what was permitted and what was not permitted and what the requirements were. That led to litigation. And not only did that lead to litigation, but what we see, and I've seen this happen several times, is that the litigation then breeds other issues. Now we've got, we're dealing with licensing issues. Folks may be applying for a license in another jurisdiction, have to disclose the litigation, and then the license gets held up. That happened to clients of mine. Dealing also with inquiries, subpoenas, and requests for information from state or federal regulatory agencies that get wind of the information. Maybe it's because an adverse party leaked it or disclosed it or made a call, made a complaint. We see that. Parties are often, you have to be, pardon me, parties have to be concerned about making threats about doing that, about making regulatory complaints or legal complaints. Oftentimes clients will say, well, if you don't, if the other side doesn't do what we want, then we're going to call whatever enforcement agency, or we're going to call the police because this party didn't do what they're supposed to do. You can get in trouble for that. The attorneys, may have had some experience with this. There's problems with potential extortion where that can get you in trouble, but it's a real thing. You have a real issue to deal with there, where if a party is not doing what they're supposed to be doing and they are violating the law, that may give rise to a duty to report these violations to an agency, or it just may expose a party to potential adverse action by a regulatory agency. I'll give you an example of what I'm talking about. Maybe this will bring it more into focus. Let's say, for instance, that you are a lab company and you provide lab work for a medical practice group, and that group bills directly to the patients and bills to the patient's payer organization, and it's Medicaid or Medicare and federal. I use federal because the federal then brings in the federal anti-kickback statute and Stark law for self-referrals, but we have those same statutes, by the way, in Florida. You have a Florida kickback statute, self-referral law, and the Patient Brokering Act that make these activities illegal. But let's say you have a lab, and the lab is doing work for a practice group, and the practice group is billing for all these services and does not remit those funds back to the lab. They keep the money. And the lab says, okay, well, you're not paying us for the work that we're doing. The lab has a claim against the medical group. The lab doesn't really have a claim against the patients. They're not dealing with those patients directly. The lab doesn't want to go after the patients. They want the medical group to pay them the share that they're supposed to be paid. Well, you have a potential kickback issue there. You have a billing issue that can lead to regulatory concerns because you've got a medical group who's billing for services that they're not providing, and they're keeping the money for those services. It can create insurance issues. It can also create potential kickback issues for both parties, by the way, not just for the medical group, but for the lab. If the lab continues to do this because they're able to get some other profitable work and they look the other way, you can find yourself in a kickback situation. All of these regulatory issues give you another reason to try to resolve things confidentially and in a private setting. And they're all issues that I believe make healthcare a little bit unique when we're talking about business disputes and mediation. Some of the issues that come up in the healthcare setting are often are a little unique as well. First one I have listed here is employment disputes. Of course, all companies have employment disputes, but physician contracts, physician employment agreements are their own animal. I review a bunch of them. I write a lot of them. They almost always have some non-solicitation and non-compete language in there, but there are some exceptions. There is, most notably, there is a statutory exception to the enforcement of non-compete agreements in Florida that applies only to medical specialties. In a nutshell, if you are a specialist, let's say you're an oncologist and you practice in a rural county in a group and you're subject to a non-compete, but there's only one oncology group in that rural county, the non-compete may not be enforceable because of that. There are compensation issues that come up. Your compensation also may be subject to regulatory overlay through self-referral, kickback, and other issues that affect physician compensation, so that it has to be fair and reasonable and fair market value and so forth. Another reason why you don't want to be potentially attacking these issues in a public forum like in a court. Other unique situations that come up are between healthcare providers and hospital systems or other groups, or referring providers. I've mentioned, physician and lab is a good example, or it could be a long-term care and a referring provider, or a MRI. I use some of these examples, but not thinking of anything in particular. But you have these relationships, medical staff, where you have issues with peer review and staff privileges in hospitals and in groups. Where you don't want to be going to court because you have a dispute, but you need a mechanism to resolve disputes. You often have peer review, a formal peer review process through the peer review panels that resolve some of those issues. But again, this is something that can be done informally by the parties, or you can bring in a third party, such as a professional mediator who acts as a neutral to help facilitate that process and resolve issues between the different positions. Insurance is another unique one with credentialing and insurance payment issues and audits. Both federal and state funded payers, and Medicaid is a state and federal, essentially a joint payment between the state and federal. And then you have Medicare that's paid at the federal level. You have these managed care contracts that provide these services, are paid through the Medicaid system, but also have a regulatory overlay. So some of the statutory interpretations and the documents that might be required for an audit, documents to support payment, may be in the statute, not in the contract itself, but you'll find that the contract will have some alternative dispute language in there. In Florida, most of the ones that I've seen usually require mediation, and a lot of them also have an arbitration provision in there. So these are, although they're standard contracts, the process for resolving disputes is a little bit different, and you have to go outside the contract and also be familiar with the fact that there are these additional regs out there that you have to look at. Administrative requirements, Florida Administrative Code is another one. So you have to know that there's reference to these other code sections and administrative materials out there, and know how those interact with the contract itself for enforceability. And all of this is also, again, in a situation where you're dealing with patient data, which is, whenever you're talking about payment issues and audits, again, you have this issue with confidentiality and HIPAA requirements for exchanging information. And what do all of those have in common? And this is where I'm coming to with some of these unique issues that you face. Yeah, some of these issues exist in other businesses, in other situations. But when you're talking about the world of healthcare, these are usually isolated issues where you still want the long-term relationship to continue. You don't want to blow up your relationship with your healthcare contract payer if you're credentialed with a particular under a particular plan as a provider. You don't necessarily want to blow that up over an audit. You don't want to blow up your relationship with a hospital over one particular dispute. So whenever there's a situation, and again, it's not just healthcare, but it comes up a lot in this context, whenever you have a situation where there's a potential for disputes, but the parties want to be able to maintain a relationship afterwards. We want to resolve this dispute and we want to move on. Litigation often is not the way to do that. When people finish a lawsuit, if they actually go to judgment, and I say people, and I'm talking about individuals or companies where the company representatives, usually even on larger companies, you'll end up dealing with a couple particular folks in the company. They often hate each other when this is done. The last thing they want to do is do business with each other. People are bitter. And so if you want to salvage and preserve relationships and get past a particular dispute, yeah, maybe people are a little dissatisfied. Maybe people are upset with each other. But if you want a way to resolve disputes and move on, this happens all of the time in healthcare and a lot of other professional services. And a good way to do that is to have some type of process like mediation, where you get the people involved, get everybody to sit down and try to work through these issues and then come up with a solution that solves that problem, and then you move on. Why go through this problem? Why go through the mediation instead of just filing a lawsuit? I've touched on, I think, throughout this webinar, but here's sort of a checklist of issues that it will help the attorneys with their clients. That's another issue, client control, maintaining it for the attorneys who want to maintain relationships with their clients after a litigation. It's interesting to think how many clients, if you really go through a trial and go through that arduous process over what lasts maybe several years, a lot of times the clients are just burnt out from the relationship. Even if they get a good result, the clients just want to move on. They don't want to deal with it. They just hate lawyers when they get done. There's a lot of stress, mental health, I put at the top here. The clarity, I talk about the issues with, for instance, the telehealth statute and how that's subject to interpretation where reasonable, smart people can disagree on what's permitted and what's not permitted. Maintaining relationships, again, what I just touched upon. Another is flexibility. If you're going to litigate, or even for like an arbitration, but especially litigation, you're going to be on the court schedule. You have a little bit of flexibility as to setting hearings and setting your schedule, but it's not uncommon to want to have a motion heard, for instance, in court, and find that you can't get hearing time with a judge. And what are we in April? I had one that I'm familiar with recently where it was August. August is as soon as time. I've had situations where it's 6 months to get hearing time. It could be a year or 2 years to get trial time. And the judge isn't doing a trial on the weekends. The judge isn't going to typically stick around and have the judge and a jury hear the case starting in the afternoon and go until 7, 8, 9 o'clock at night. It's changing a little bit as far as being able to appear by video. But oftentimes judges are still going to want you in the courtroom. Again, more so before COVID than now, but you still have that issue. Having all of that flexibility. You can, I've done, especially in healthcare, when you have practitioners who are on a surgery schedule, trying to run a business, seeing patients during the day. They want to start they want to do everything else, all their admin, and that's what they kind of consider a lot of the dispute resolution process is part of their non-patient practice, let's call it. And they may want to start later in the day. in the afternoon, and you may end up going in the evening or do something after hours, starting at 1 o'clock, 3 o'clock, 5 o'clock. We did one last week with a couple folks, with the physicians, and we started at 1. We went till about 9. Last night we went till about 10 to get things resolved. You can't do that. If you're, generally speaking, if you're in court, you're not going to have that flexibility of the schedule and allowing people at different locations to all meet at a certain time. Being able to choose a neutral forum. Most contracts, if you have a litigation provision, will also have a venue provision in it that says that the venue's got to be in a particular state. And if you either don't pay attention to that when you negotiate the contract, or if you are in the weaker bargaining position on the front side of the contract, then you'll often be stuck taking your lawsuit to somebody else's home turf, whether that's in a different county in Florida or in a different state. You have to go to New York or Delaware or Nevada or wherever it is. With mediation, the parties can all agree to meet somewhere at one joint location, or what's more common now is you can agree to do it by video, and the parties can all get together. Let me add something too on the video and the Zoom depositions, or pardon me, on the mediations. I was a little skeptical. I think a lot of people are skeptical on how effective it would be, and I think it was tough to get folks to really sit down and hammer through tough issues and resolve disputes unless you had everybody sort of in the same building. And with the mediations, you start in one room and break off in your different caucus rooms. But unless everybody was sort of stuck there and stuck in the process, it was much harder for people to walk away. People were more engaged. They wanted to fight through the process. And I felt like that was going to be more successful. And I still think that has its place. I'm not a big fan of the mediation where everybody is in a different location. But if you are going to do a mediation, I'll suggest, I've had this now a couple of times where I think it works well, where you have at least the parties and their own attorney all in one room. And for the attorneys, you'll know you have better communication and better control with your client, with the process, if you have all of one side all in one room, and then they can be on video, maybe all of the other side in another room on video. And then maybe the mediator is able to work between those two groups instead of having 6 or 8 different screens. I found that during with video conferences, up to about 4 or 5 people makes an effective conference. But when you have these things where there's 20 people on the screen, people tend to get washed out. And I think that's a better process for mediation, to have folks as much as possible together, and then you put them on the video screen. We've had real good success doing it that way. Costs, embarrassment, just of being in court and being in disputes, and folks who when you get deposed, that deposition transcript can oftentimes become part of the public record. Even if you go to litigation, you don't go to trial, you can have a deposition. It really makes you or your client look bad. And then also, one very unique issue for healthcare is that some things, if you end up in court, or if you end up in a formal dispute process, depending on the resolution of that, or what the situation is, you could be subject to reporting in a national practitioner data bank that follows you wherever you go in your career. And if you, in mediation, as I said earlier, you can craft remedies that may not be available to courts, or may not be available. You can't violate the law. You can't enter into an agreement that's illegal, but you may be able to do things that there's no remedy in the courts or in the statutes or in the regs for, and craft a unique remedy. And one is, if you're dealing with a dispute and you're representing a physician provider, consider negotiating whether there is you can negotiate away a requirement to report into the MPBB database, or at least you can negotiate the language that goes in there. So if you have, for instance, a physician who's getting, is being forced off of a staff or losing privileges somewhere, and that would be a reportable incident under the reporting rules, you can negotiate the language that goes into the data bank, or maybe you can negotiate away, come up with some resolution that keeps that out. And that's huge. It's something that can follow a practitioner for a long time and be detrimental, and you have an opportunity to negotiate that away. Mediation versus litigation. One of the main I've touched on privacy and confidentiality, but it's a much faster process. And the big issue here is your ability to control your destiny and control the outcome. And by that, that's not to be misinterpreted or misunderstood to mean that you get everything that you want, but you don't have to do anything that you don't ultimately agree to. And more often than not, clients and parties, when they finish mediation and they have a chance to reflect on it, are glad they did it, are glad they went through the process, and glad they, if they resolve their case, they're usually happy they did. I more often the feedback I get in my experience has been that people are glad to just have everything done and resolved because of the stress that it creates. If anybody reads on psychology and stress and just decision fatigue, for instance, people having to make decisions and the stress that it's not a noticeable stress, but it's a measurable stress that psychologists can identify. And just having to pick out, what you're going to wear every day, or what you're going to eat every day, and from that is where some of these concepts of minimalism come from. And if you're in a lawsuit, you have these tremendous costs of time and emotional energy, in addition to the monetary cost to deal with. And you have an opportunity to contain that and at least have some control over it, to control the outcome. And for the lawyers, again, a tip here: there's no worse pressure for me than having a long-term client that I've had a relationship with for many years, and being involved in a litigation that could really not only be harmful to the client, but in the process of harming the client or the client's business, also harm your relationship with the client. There's a heck of a lot of pressure there when you're dealing with, especially if your client's not in a good position, or if your client did something wrong, or they're not being realistic, and you're in a situation where you could potentially go to a hearing or go to trial or some type of formal process where your client gets a bad outcome, and you could lose the relationship, and the client could talk bad, and you could lose your relationship with others, or it could make things very difficult for you. And a lot of my long-term clients are friends of mine, and I want to maintain those relationships. And again, you have the opportunity when you can at least get everybody on board with what the resolution will be. It may not be the most palatable to everybody, but when everybody agrees to it, it's oftentimes a better outcome than let somebody else make a decision at the risk that you're going to get an adverse outcome. My own little formula here: I probably am not the first person that's thought about these issues, but this is what I give to pretty much every client, and I explain this when I am doing mediations for folks. This is your cost. You have not only the dollars that it costs you for your own legal counsel, for legal expenses and fees, expert witnesses, costs of depositions, costs of other service of subpoenas and foreign subpoenas, and gathering data and information, and e-discovery management. You can spend hundreds of thousands of dollars, obviously, even on disputes that aren't worth hundreds of thousands of dollars. Then add to that the stress and emotional toll that takes on the client, or takes on the client's staff, or both, whoever's responsible for dealing with the litigation, whether it's an individual, or it's a small business owner, or a small solo doctor, or other type of healthcare provider, or a group, and there's somebody who's responsible for that. And then the time and how much staff or how many people are going to be dedicated to preserving and pulling documents and records, and preparing for depositions, and preparing for witness statements and affidavits, and reviewing documents, and talking about the case. All of these things are things that just go on and on and on. And if you're involved in a lawsuit that goes on for a couple of years, this is going to continue. So, if you want to, sometimes, maybe you had to resolve something, you're looking at spending a little bit more money. You say, well, if I wait, I could probably sell this for less, or my risk of a final judgment is going to be much less from a monetary standpoint. But you also have to think about these other components here. What type of toll is it going to take on you, on your staff, on other folks, on your family, on your relationships, if you continue in an environment outside of what your bread and butter is, which is providing healthcare services to patients and clients. So there's consider that cost. I want to touch here the last slide of substance here on the new issues and how mediation and the alternative dispute resolution process might be used in the future, and other issues that might come up other than just formal dispute resolution between parties who might be in litigation. Think about, I mentioned earlier, with groups buying up small practices and consolidating practices, physicians and other types of healthcare providers are losing autonomy, being wrapped into larger groups or larger hospital systems. Disputes arise there when people feel like they're losing control of their practice. You may have an opportunity to resolve employment issues, HR issues, other types of conflict management within your system. If it doesn't work with just sitting and having a meeting, consider the idea that maybe having a third party neutral come in that doesn't side with the employer or the employee, or doesn't side with one group over the other, but is truly just a neutral party who can help facilitate a resolution. How can that help make your business, your healthcare business, more effective? And how can it help in the dispute resolution process? I think we're going to be seeing more of that. Obviously, especially after COVID, people are struggling with staffing issues, human resources, just getting people to work, keeping people happy, burnout issues, stress over economy and compensation, and then the diversity, equity, and inclusion issues that we're seeing now a lot of. These are all areas that are ripe for potential dispute and also present opportunities to create alternative mechanisms of dispute resolution within the system. So you might consider, have clients consider bringing in somebody, an outside person. I've done that with clients where we've written that into governing documents, where if there's a dispute, rather than going to court or doing something else, they pick a panel of one person or three people that they'll have help them resolve a dispute internally, so it doesn't carry outside their business. And with that, I don't know if I may have a minute or two for questions. I know there's a chat here, so we'll do questions. There's my information. And let's see, as we're up here, if you do have any questions, anything I covered today that you want to know more about, I would love to have you reach out. My contact information is, oh, it was here, there it is, on the slide there. So you can find me either on social media, LinkedIn, or at our firm website, or email, or call me. You have a copy of the materials there. I thank you for the opportunity to speak today. If you'd like credit, I think there's a mechanism for you to apply and get credit for today's webinar. And also, I would love if you would consider, I'm very passionate about this topic, and I would love an opportunity to mediate any type of disputes that you may have that arise that may be appropriate for professional dispute resolution. And with that, I wish you all a great day. Bye-bye.